Hello, I'm Jessica Ryan Keeney. I am the attorney for two small Northern California Department of Child Support Services counties, one of them being Lassen County Department of Child Support Services. Welcome to our channel. If you haven't done so already, ding the bell so that you get notifications, like the video, subscribe, all that good stuff. If you have any questions or comments, feel free to put them in the comments below. Keep in mind that nothing about this video or any of the discussion in the comments is legal advice. This is for educational purposes only, and it's your job to make sure that you seek the advice of an attorney who can analyze your case, the facts, the law, answer all of your questions, put it all together in a fashion that's appropriate for you. But this is a good jumping off point for legal discussions and for education. And so today we're going to do something that we haven't done before, and that is go through some of the comments on some of the videos and answer some of the questions. Again, not legal advice. You're going to get to see a lot of my profile today as I look at my computer screen. So the first video that I'm going to look at comments on and answer questions on is other tax settings in the California Guideline child support calculation. Now keep in mind that this applies to California only. Don't know what other states are doing. Okay, so somebody asks, can I ask the court to consider my tax liability as married filing jointly, not with parent two, to fulfill our federal and state tax obligations? My spouse makes twice as much as I do. And so the answer to this is that the tax filing setting in the calculation needs to reflect your actual tax filing setting, because basically the calculation is a tax calculator and it's going to calculate your tax obligations in conjunction with your income to figure out what your net income is so that it can calculate guideline child support. So again, make sure that the calculation reflects your actual tax filing status. And the way you can do that is fill out an income and expense declaration and make sure that information is accurately in that income and expense declaration. That income and expense declaration asks about what your tax filing status was for the last year that you filed taxes. Well, this coming year, you might have a different tax filing status. So you might need to include that information elsewhere in the income and expense declaration. I might include that in the bottom of page 4 and just explain what the current tax filing status is going to be. The next set of questions come from our video, How to Ask the Court to Impute Income to a Parent. Okay, so one question is if I would mind sharing a link or pointing this person in the right direction for an example of the declaration that is described in that video. It looks like they looked on my website and they didn't find that declaration. Could have swore I had it. I am happy to do that. I'll have to go look at the website and make sure an example of that declaration is there. Pretty sure that I typed out an example of that declaration in the video as well. Okay, this person says that they were able to get the judge to impute income to an unemployed or an underemployed custodial parent at $20 per hour full-time. I know that's not a question, but sharing it anyway. Okay, this person wants to know if we have any recommendations or guidance for imputing income to the custodial father that that refuses to speak to the non-custodial mother. The DCSS ordered child support on this particular person for their 2 kids last year, and apparently the father has had no job since moving to California 5 years ago. He lives off food stamps or his and his girlfriend's illegal growing operation. This commenter lost everything except the house since being put on this program, and that's only because the landlord agreed to receive reduced rent if this person paid interest. So I'll start by saying that it's not DCSS ordered child support. The court ordered the child support. DCSS might have come up with the calculation, but it's actually court ordered child support. And I will also say that I'm sorry for the hardship that this commenter is going through. So there's, again, this isn't going to be legal advice, but there is nothing magical about asking to impute income to the custodial parent, or about the custodial parent not speaking to the non-custodial parent. The process to ask that income be imputed is the same regardless of the parent that you're asking to impute income to, whether that's the mother or the father, whether that's the custodial parent or the non-custodial parent. And the key is put it in the motion, or let's say like the department has filed a motion to modify child support and you're responding, put the request in the response. That support should be based on imputed income, and say who you want the income imputed to. And remember, there needs to be the ability to earn, the opportunity to earn, and you've got to show the amount that the other parent can earn. And so I see courts readily impute full-time minimum wage, but the court needs to make the finding that the parent they're imputing income to has the ability to earn the income being imputed, the opportunity to earn the income being imputed. And so one should never take for granted that the court is automatically going to make that finding. What I do in my private cases and what I've done in some of my DCSS cases is I go and I look on Indeed.com. I like Indeed.com a lot because of the way that I can sort the jobs and the distance and all that good stuff. And so I will look for jobs in certain areas, and if the person doesn't have any specific skills, then I will just look for general entry-level jobs. I will create a table that shows the search terms I used, the city that I was searching in, the distance around that city, and how many jobs popped up for that particular category. And, if I know that the person has experience working in a kitchen, then I'm going, like at a restaurant, then I'm going to make sure that I'm looking for restaurant jobs, cook jobs, chef jobs, not the higher level ones, but the entry level ones, unless I know that they have particular training and or experience that would allow them to work more than those entry level jobs. If I know that the person has experience as an office worker, then I will specifically look for office worker jobs. If I've got a parent who has never worked in an office in their life, but they've worked at a parts counter or they've worked as a mechanic, then I'm probably not going to be searching for office jobs for that parent. I'll probably be searching for mechanic jobs at a parts house. And then when I'm looking for entry-level jobs, there are certain jobs that I typically look for regardless. And those would be things like grocery store cashier, grocery store stalker, retail jobs, gas station jobs, and you should have an idea what the standard entry-level jobs are in the area that the other parent that you want income imputed to lives in. And so that helps show the opportunity to earn. And then I need to go through an analysis about the ability to earn. And if you want the court to impute income, you need to go through that analysis yourself. And I detail that analysis in my video. Not a lot of counties go through the full-fledged analysis, and when I stopped doing the motions for my counties, the case managers did not continue to go through that analysis. I wouldn't be surprised if we're going to start going through that analysis in the near future, and when I say we, I mean DCSS, due to new laws. that have been enacted. So it says that this parent is living off of food stamps. So there's nothing about food stamps that make it so that income can't be imputed to that parent as far as my reading of the law goes. However, if that parent is receiving CalWORKs, then income cannot be imputed to that parent. We have a video about that. If they're receiving cash aid that's not CalWORKs, then per my reading of the law, and again, we have a video on this, then the court can impute income to that parent. Some say that there is a split in decision on that, and I disagree that there's a split in decision. I think that there is an obvious distinction between someone receiving CalWORKs and someone, say, on general assistance. So hopefully that helps. The other thing to keep in mind is that if visitation is 0, then imputing income to the custodial parent isn't going to make a big difference in child support. Might not make a difference at all. But, might not be visitation with the kid or kids right now, but in the future there may be. So even though imputing income right now may not change the calculation, may make it easier to get income imputed in the future, because there would need to be a substantial change of circumstances for the court to fail to impute income in the future. Hopefully that helps. Again, not legal advice. This next person wants to know if I have attachment 10 that I went through available. Didn't see it on my website. And so attachment 10 is something that a person can create themselves. They can either go to the Judicial Council website and download the miscellaneous form or the declaration form that's intended to be attached to a motion, and they can label it attachment 10. They can do it on pleading paper in a word processor and label it attachment 10, or they can just pull up a Word document, label it attachment 10, and write what they need to write in that document. There are specific rules of court about font size, spacing, all that good stuff. Basically, go read the rules of court. But if you're using 12-point font, Times New Roman, you've got 1-inch margins all around your paper, and your spacing is 1.5 times or double spacing, then you are probably going to meet the requirements for font and spacing and all that good stuff. Let's see, and when I say label it attachment 10, put attachment 10 like up at the header, right? Because if you just put it in the file name, the court's not gonna know that that's attachment 10. Okay, and this person wants to know, should we use the term mother or use her name when writing the declaration, or does it matter? Really, it doesn't matter if you use mother or father, or which I call those character names, right? Because that's the character. Might sound bad to say, but that's how I refer to them. That's the role they play in the case. They will always be mother. They will always be father, except in very rare situations. And then you can call them Mr. or Mrs. And sometimes parties have the same last name in a family law case, and so they are called by their first name, or you can call them petitioner or respondent. Now, I find that a lot of people mess up who the petitioner and the respondent are, because they think if they're the one who filed the motion, now they are the petitioner. Well, if they didn't open the case, they're not the petitioner, they're the respondent. And so and sometimes the court caption on the document is wrong, and they just have the wrong information. So, you could be saying petitioner and respondent, and you realize you're referring to certain people, but you're actually mistaken, and then the court's totally confused about what you're talking about. So I generally don't encourage people to use petitioner or respondent. I one time years and years ago had a court that started to be a little bit unhappy about me using the term mother and father, and this was not in a child support case, and this was not in Lassen or Plumas County. This was in a bigger county, and it was in a family law case, a private family law case. And I explained to the court that the reason why I use the terms mother and father is because it reminds us that this is a family. This is mom to these kids. This is dad to these kids. That is always going to be mom. That is always going to be dad. And we need to remember that we are dealing with a family, and we're dealing with someone's mom, and we're dealing with someone's dad. And the court seemed quite pleased with that answer. Another reason why I use mother and father is because it's usually easier for me not to mess up names. You know, if I've got a bunch of cases on calendar, I might mess up Mary and Marlene when I'm talking about the case, but Mary and Marlene are probably both moms in their own cases. And I would hate to accidentally call somebody the wrong name in a case. Also, sometimes it's not easy to tell who's the mom or the dad when you're saying the name. So let's take the names Lauren and Terry, right? So there is a male and female version of the name Lauren. There might be for Terry as well, but people don't necessarily write those names out properly. And you know, you hear the name Lauren, you hear the name Terry, doesn't necessarily indicate you are dealing with a male or a female, doesn't necessarily indicate you're dealing with a mom or a dad. I realize labels can be complicated, but you know, in general, this strategy works for me. And so I use it. And so, you know, if I say mom and dad, in general, it's pretty easy for the court and for me and for everyone involved in the case to look at the parties and be like, that's who the motion's talking about. Dad, right there. That's who the motion's talking about. Mom, right there. The other reason why I started going with what I call character names is because when I was a law student working for my mentor and I was going through his files, it was really difficult for me to keep track of everybody and their names. I mean, the parties, you know, mom and dad, I could keep track of them, but it might take me a little bit for it to, you know, settle in my mind their names if they had names that were gender ambiguous. And then when people would change attorneys, it became difficult for me to keep track of whose attorney was whose. So I'd have mom's attorney, dad's attorney. And so I decided that that was a good strategy to employ as well, because if I was having that trouble, then legal assistants in the future may have that trouble as well. And so if I just always wrote my motions using the character names and wrote my case notes using the character names, then whoever came after me in that case would be able to make more sense of who we were talking about, and there would be less confusion. But again, I go back to these people are mom and dad. This is a family. We are dealing with children, and we need to remember that what we're doing in these cases is going to impact this family for the rest of their lives. So while those other things, you know, those other reasons why I use character names, mom, dad, are legitimate, I feel like I'm not being insensitive to the family because it still centers me, centers everyone else, and reminds us this is a family. This is someone's mom. This is someone's dad. These are children that we're dealing with. And so, you know, it's really up to you how you're going to refer to the other party in your pleadings, in your paperwork. Just make sure that it's respectful. And if you're going to do petitioner and respondent, which I do not recommend, make sure you get it right, because that, referring to them wrong, getting that reversed can really confuse things. I did an entire motion once when I was a law student where I referred to the petitioner as the respondent and vice versa. It was confusing. This person wants to know, how do you reword the declaration when DCSS requests to modify child support? And so it looks like this person was probably looking at one of our videos and was wanting to know, how can this be reworded for our situation? And basically, you know, just tell the court what you are asking for. You know, just like DCSS tells the court what we are asking for. We are asking the court to order mom to pay X amount of child support, whatever it is. But just ask very clearly for what you want the court to order, and then explain very clearly why you want the court to order it. The writing in this does not need to be particularly sophisticated. In fact, the more sophisticated people try to make the writing, the more difficult the paperwork is to read. So try to write your paperwork so that a fifth grader could understand it. The judges are going through this paperwork very quickly. They have a lot of cases that they need to prep for, and although they've had many years of school and many years of experience, if you can write it with a fifth grade understanding level, the judge is going to be able to understand what you want and why you want it so much easier, and the other party will understand as well. Okay, and this next person wants to know, if the other parent doesn't do an income and expense declaration, can one do interrogatories? And I mean, the quick answer is yes, but you might not want to. So discovery is a very specific tool to get information that you're looking for. There's very specific laws that apply to discovery, including deadlines. And if you don't do discovery just right, per the letter of the law, then you could be sanctioned, which means that you could be ordered to pay money as punishment for doing a bad job or doing it incorrectly, or you could miss deadlines, you could miss the opportunity to discover certain things, and interrogatories aren't the only form of discovery. So I'm of the general mindset, and unfortunately I don't get to do this in the child support cases because my child support clients, DCSS generally don't like me to, but in my private family law cases, I'm of the general mindset that if somebody isn't going to do an income and expense declaration, they're probably not going to respond to my discovery requests either, be it requests for production of documents or interrogatories or whatever. And so if I really want the actual answer, then I'll just go subpoena the documents straight from the source. So if the parent doesn't do an income and expense declaration in my private cases and I know where they're working, I will just go subpoena their pay stubs and their income and withholding information and whatnot from their employer. If I think they're hiding money, then I will pay a private investigator to do an asset search. And then when I get that asset search back, I will go subpoena records from financial institutions based on what comes back on that asset search. Discovery can be complicated. There might be times that I want to limit the other parent's ability to produce certain evidence. And so if I want to do that, then I might do discovery requests, and then when they don't respond, I'll go through all the proper steps, or when they don't respond completely, go through all the proper steps, because there's several, and then eventually I may ask for an order that they not be allowed to produce evidence on that particular issue. But then I still need evidence of some sort on that issue. So, I got to have a game plan. So discovery can be very complicated, very technical. Interrogatories, requests for production of documents may or may not be the best thing to do in your case. Make sure that you speak to an attorney who can advise you about what to do and how to do it. The other thing about discovery requests, so things like requests for production of documents, interrogatories, requests for admissions, is that can be expensive. It can get expensive quickly. And so if I subpoena the records that I'm looking for straight from the source, I'm probably not going to get an order from the court that the other parent pay for, the subpoena, my work to do the subpoena, the production fee. That's something that my client will have to eat because I chose to jump to that instead of going through the discovery process. But considering it's not unheard of for discovery to cost a minimum of $5,000 and it can cost far more, it's often a lot cheaper for my client just to eat the cost of the asset search and subpoenaing the documents, and then the production costs. And again, I'm talking here about with my private clients because unfortunately the Department of Child Support Services usually doesn't let me have a lot of fun doing those things. This next person wants to know who pays for the vocational evaluation, and that really depends. So I have seen situations where the party paying for the vocational evaluation, the party requesting the vocational evaluation pays for it. I've seen situations where the party split the cost of the vocational evaluation. I've seen situations where the party asking for the vocational evaluation fronts the money for the vocational evaluation, and then the court reserves jurisdiction later to make a different order about who's ultimately going to pay for it. So maybe dad wants mom to undergo a vocational evaluation. He gets an order that mom undergo a vocational evaluation. The court may order dad to pay for the vocational evaluator and then reserve jurisdiction to modify that order later. So even though today dad might pay for the vocational evaluation, the court 6 months from now might order that mom pay for half of it or all of it or some portion of it. Now, something to keep in mind is if you, again, not legal advice, but if you want the other parent to undergo a particular evaluation or you want something to happen in your case, if the court orders that the other parent pay for it or that you guys split the cost and the other parent doesn't pay for it or doesn't pay their share, then they can make the case drag out. And so by fronting the cost of what you want to happen in the case, subject to the court reserving jurisdiction to modify that order, you can often get the case to move along much quicker. So that's all the questions we had on this particular video. Thank you so much. Keep those questions rolling. Please remember, none of this is legal advice. This is for educational purposes only. We sure do appreciate you watching our videos. Go ahead, like the video, subscribe, ding the bell so that you get notification when we upload new videos. Put questions, comments in the comments below. Our responses, the discussion, none of it will be legal advice. It's all for educational purposes. Thank you so much.